Some constitutional clauses dominate the American polity. Indeed, the recent decision concerning Obamacare, the Patient Protection and Affordable Care Act, featured nonstop soliloquies on the Commerce Clause, the taxing powers, and the general power of the national government versus the power of states. Similarly, the Second Amendment in recent years has reared its head again. And of course, continuing discussion about gender, racial, sexual equality might lead us to believe that there are only a few important clauses in the Constitution, or a few operative clauses in the Constitution. But we don't have to look very closely at the document to see that there are a few other kinds of clauses. There are some clauses that are underused. In other words, they're clauses that might only have been used once or twice in the history of the Constitution. There are some that have fallen into desuetude. In other words, were important clauses and were litigated in very prominent cases, but have never been litigated since. And there are also clauses which have never been litigated or used at all. And I'm going to talk about an example of each of those categories. One of them is the Republican Guarantee Clause. Another is the Privileges and Immunities Clause of the 14th Amendment. And the other is the Third Amendment to the Constitution, which is one of the Bill of Rights. So let's start with the Republican Guarantee Clause of Article 4, Section 4, which states, quote, "The United States shall guarantee to every state in this union a republican form of government, and shall protect each of them against invasion, and on application of the legislature or of the executive, when the legislature cannot be convened, against domestic violence." There really is no agreed upon, or there's really no evidence that would say with certainty what definition of republican government the founders had in mind with this clause. Nevertheless, the Constitution says that the national government will guarantee to every state in the Union a republican form of government. The very least which we can say about this clause is that the term republican means, at the very least, something different than monarchy. So, in a sense, the national government will guarantee that every state will not be a monarchy. Well, that's not enough, some would say. And there have been a few times in American history where this clause has been used. I want to give some examples of this. Certainly, if there was an insurrection or a riot, the national government would be bound, according to this clause, to come in and protect the state from an invasion, whether it be foreign or domestic. But it also says that it guarantees to every state a republican form of government in the state. So it's functioning. Each state has to have a functioning, in a sense, republican form of government. What does that mean? Well, we've only had a few examples of this, or a few times in American history when this has come about. The first time was in the 1840s, a case out of Rhode Island. Rhode Island had, in a sense, two competing sets of state legislators. They went to the polls, and they voted in one set of legislatures for their state government. But there was a significant amount of people who were disaffected with the outcome of that election and held their own election and elected their own set of legislators. Well, they both show up at the State House. Who's going to take the office? Well, this case makes it to the Supreme Court. And it makes it to the Supreme Court, and the question is, well, is this a republican form of government that's here? Maybe the national government should chime in and tell us what it means. But the court punts. It says this is a political question, not a judicial question. So the first time that the court weighs in with respect to giving meaning to this clause, guarantee to every state a republican form of government, seems to suggest that it wants Congress to decide, or it wants elected representatives to decide what the word republican means, and therefore what a republican form of government is. Well, this clause is never used again for another 25, 26 years, because it does rear its head again during Reconstruction. Those years immediately after the Civil War, which were designed to bring southern states that had seceded back into the Union. And this makes a lot of sense for the clause as a whole. Certainly there were insurrections in states, and that would be one way to justify federal intervention. But also, the structure of a Republican government, what does that mean? Well, it probably wouldn't mean, if we think about it, it probably would not mean a state which specifically allowed slavery, or a state which explicitly trampled on the rights of a huge part of their population, meaning freed slaves, freedmen. So there were many in the Congresses immediately after the Civil War that argued that the northern occupation of southern states, and during that occupation there was mandatory voting by bayonet. They would allow African Americans, freedmen, to vote, and by bayonet northern soldiers would be down there. Some said that was unconstitutional. Others, though, said no, this is guaranteeing to each state a Republican form of government. Well, the clause is never used again for another 100 years, during the period which we call America's Second Reconstruction, which were basically the voting rights revolution and apportionment revolution and equal protection revolution concerning race during the 1950s and 60s. The Republican form of government, the guarantee that the national government maintain or guarantee to every state a Republican form of government, was used by some to justify the sweeping kinds of federal changes, federally mandated changes, particularly in southern states, concerning the ways that they had been conducting their elections since the late 1880s in the United States, basically to get rid of what we and you know as the period of Jim Crow in the United States. You know, the kind of social and oftentimes social and legally mandated segregation and racism against African Americans. So again, the idea would be, if you had that on the books as a particular form of law, which many states did, that you cannot have blacks and whites going to school together, or that blacks cannot vote. Well, they don't say that, but they would say, we have to ask you how many bubbles are in a bar of soap before we will allow you to register to vote. And they would let whites answer whatever number they want, and they would say African Americans had the wrong answer. That kind of thing going on in your state, whatever that is, it's not a Republican form of government. But since the 1960s, we haven't seen anybody use that clause to make the argument that any state's functioning violates whatever we might imagine to be a Republican form of government. The next clause, which has really fell into desuetude, in other words, was used once, but then it's really gone away, is the Privileges and Immunities Clause of the 14th Amendment. The 14th Amendment was passed immediately after Reconstruction. It was part of the Reconstruction Amendments. The 13th Amendment outlawed slavery. 14th Amendment, which I'll talk about in a second, and then the 15th Amendment, which prohibited states from discriminating against people in voting based on the color of their skin, did not give African Americans the right to vote. It just said you can't discriminate against people in voting based on the color of their skin. And of course, there was the 14th Amendment, which did many things, but its most novel parts were new regulations on what states could not do to their citizens. Could not deny you due process of law, could not deny you the equal protection of the law, and it could not abridge your privileges and immunities. What are our privileges and immunities? Well, I have no idea. I think I have an idea, and I would like to imagine that there are millions and millions of rights I have, millions and millions of privileges and millions of immunities. But you might disagree with me. You might disagree with me. You might think we only have one. You might think we have 3 million of each. It just simply doesn't tell us what our privileges and immunities are. And when we look back for help to the federal courts, we get even less of an answer. We get a little bit of an answer. The first time that the Privileges and Immunities Clause, by the way, the term privileges and immunities is used in the unamended Constitution as well. So maybe we could see what the court said about that. There was a case called Corfield versus Coriel in 1823, which involved Pennsylvanians and New Jerseyans arguing over oysters. And the question was asked, well, whether oyster farming is a privilege or immunity of citizenship. However the court decided that is not important for our purposes. What is important is what they said our privileges and immunities were. And the justice in the circuit court opinion said, look, there's too many of them to list. I'll just tell you what the categories of things, I'll give you categories under which at some point we'll decide what our privileges and immunities are. One of the categories is protection by the government. It's not very helpful, is it? The enjoyment of life and liberty with the right to acquire and possess property, and to pursue and obtain happiness and safety, subject nevertheless to the restraints as the government may justly prescribe for the general good of the whole. That's not very helpful, is it? So the 14th Amendment, one of the most important amendments ever, says that states cannot deny you your privileges and immunities, but we still don't know what they are. Well, not soon after the 14th Amendment was passed, the Supreme Court for the first time had the opportunity to tell us what privileges and immunities were and what they looked like in a case called, the combined set of cases called the slaughterhouse cases. Well, when asked what, in a sense, our privileges and immunities are under the 14th Amendment, the court made reference to Corfield versus Coriell and that quote that I just read, and then simply said nothing else about the Privileges and Immunities Clause, and instead relied on the Due Process Clause of the 14th Amendment to resolve the particulars of that case. Well, since then, the Privileges and Immunities Clause, as many scholars have characterized it, has been strangled in its crib, because that was the first, and since then, for the most part, the very last time that anyone has made an argument that something that's being done to them by their state violated their privileges and immunities of citizenship. The last time that that argument has been made and seriously considered by the Supreme Court. There are also certain clauses that have never been implicated in any meaningful way in American constitutional history, litigation, or law. The Third Amendment is one of those examples. The Third Amendment, which is part of the Bill of Rights, says, quote, "No soldier shall in time of peace be quartered in any house without the consent of the owner, nor in time of war, but in a manner to be prescribed by law." This is a very straightforward clause. We're not allowed to, the government is not allowed to quarter or to force troops to live with you except during a time of war, and then only in a way prescribed by law. Certainly, there was an American experience with the quartering of soldiers, and it's easy to explain where the Third Amendment came from, what the concerns were. British soldiers had been quartered in American homes. There was also a larger historical memory of the educated class among the founders of the quartering of soldiers in homes in Europe, which were one of the ways that the wars of religion of the 17th and early 18th century were fought, not only to prosecute the war, but to convert those. They would leave soldiers in the house, particularly in Huguenot Protestant homes in France, until they converted to Catholicism. So it's kind of straightforward to understand what the framers' concerns were and why they were so concerned with saying that this was a right. In other words, that this was something that we were protected against. But it's also, it's never reached the Supreme Court. There was a case in the 1970s involving prison guards in Pennsylvania who had temporary housing, but it really has never, thankfully, really been an issue in the United States. So it's really never been used. But when you look at it, though, it does allow the quartering of soldiers in our homes. It has to be during war and in a manner prescribed by law. So, but that suggests not that the framers thought that quartering of soldiers was good. They thought, what it suggests is that they thought it was necessary, but had to have the legitimacy that's backed up by law. In other words, we would have to agree what that would look like. If we had in the future to quarter soldiers in our home, we would have to agree what that would look like, the processes by which that would happen. So whether it's the Republican Guarantee Clause, the Third Amendment, or the Privileges or Immunities Clause, clauses which have only been used a few times, clauses which have been used once and then gone away, or clauses which never have been used, that doesn't mean that they're unimportant, because what we still see in them are the principles that permeate our Constitution, and that's that the recognition that the government is founded upon popular sovereignty, as we saw in the Third Amendment, for example. If we're going to have this, it has to be done in a manner prescribed by law, and the law comes from the people, and there has to be limited government. These two ideas of popular sovereignty and limited government permeate the Constitution. So, we can see them, and what I don't want us to do is to think that these are unimportant clauses because they were used once and never used again, or never used at all, because we can see in them the foundations of American constitutionalism: popular sovereignty and limited government. Thank you.
Freedom 101 is made possible by generous support from Woody Young and the University of Oklahoma Alumni Association. Freedom 101 is a program of the Institute for the American Constitutional Heritage at the University of Oklahoma. For more videos and podcasts, visit freedom.ou.edu.